I'm Dennis Brager. I'm a former IRS trial attorney and a California State Bar certified tax specialist. This is just one in a series of videos designed to give you answers to questions that my clients frequently ask. Today we're going to be talking about what is an IDR. IDR stands for Information Document Request. An IDR is issued on IRS Form 4564. It is a form that the IRS uses during a tax audit to request information from the taxpayer. In many tax audits, the IRS will issue an IDR at the very beginning of the audit and then issue additional information document requests as the case progresses. IDRs are authorized by Internal Revenue Code Section 7601, which empowers the IRS employees to, quote, inquire after and concerning all persons who may be liable for any internal revenue tax. Code Section 7602 also authorizes the IRS to examine any books, materials, data, or papers which may be relevant. Not even are relevant, just may be relevant. Although it might not seem like it, there are options in how to respond to an IDR. However, if you do not respond to an IDR, or the IRS doesn't like the answers you give, then it's quite possible that the IRS agent assigned to your case will issue a summons. The IRS is authorized to issue summonses pursuant to Code Section 7602. That section grants very broad authority for the IRS to, number one, summons any person liable for a tax or anyone having possession or control over papers to appear before the IRS to produce any such papers or other data, and two, to take any relevant or material testimony under oath. One court has even said that the IRS can investigate and issue a summons merely on the suspicion that the law is being violated, or even if it just wants assurance that it is not being violated. Despite this very broad language, the courts have placed various limits on the IRS power to summons documents and information. Some of these limits are set forth in the U.S. Supreme Court case of United States versus Powell. Under the so-called Powell requirements, the IRS must show that four things have occurred. One, the inquiry is being conducted for a legitimate purpose. Two, the inquiry is relevant to that purpose. Three, the information being requested is not already within the possession of the IRS. And four, the administrative steps that the Internal Revenue Code requires have been taken. In Powell, the Supreme Court stated that an improper purpose would include where a summons was issued to harass the taxpayer, to put pressure on the taxpayer to settle a collateral dispute, or for any other purpose which was not in good faith. A summoned party who fails to comply with a summons may be subject to criminal prosecution. However, it's more likely that the IRS will simply begin a civil proceeding in federal district court to enforce the summons pursuant to the tax code. A summoned party who fails to comply with a summons may be subject to criminal prosecution. However, it's more likely that the IRS will simply begin a civil proceeding in federal district court to enforce the summons pursuant to the tax code. Strangely, IRS summonses are not self-enforcing. The Supreme Court has held that an IRS agent cannot compel the witness to appear, nor impose sanctions for failing to appear. It's only once the district court, after a hearing, has issued an order compelling the taxpayer to appear, and she fails to do so, that the district court can impose sanctions on the taxpayer. Those sanctions can include fines or even jail time for contempt. Another bar to the enforcement of a summons is set forth in Internal Revenue Code section 7602D, which prevents the use of a summons where the IRS has already referred a criminal tax case to the Department of Justice. The phrase referral to the Department of Justice is defined in some detail in the code and is limited to situations where the IRS has recommended that the Department of Justice start a grand jury investigation, the IRS has recommended a criminal prosecution, or the Department of Justice has made a request to the IRS for tax returns or tax return information of any person under Code Section 6103H. Taxpayers and other summoned parties have various rights that can be asserted in connection with a summons. These include the right to be represented by counsel, the right to invoke the Fifth Amendment privilege against self-incrimination, and the right to assert various other privileges, including the spousal and marital privileges, the doctor-patient privilege, or the federally authorized tax practitioner privilege, and also the right to make an audio recording of the summons hearing. Tax litigation lawyers spend a lot of time thinking about how best to respond to IDRs in a way which is most appropriate and does not reveal any information that is covered by attorney-client privilege or other privileges. In addition, they may seek to negotiate the boundaries of the IDR so that they do not invoke an undue burden on the taxpayer. In order to do so, however, a complete understanding of the consequences of the failure to respond are necessary to properly advise a client. If you found this video helpful, please let me know by leaving a comment. And if you would like me to update you when I post a new video or send out a newsletter, please send an email to zleviste, that's ZLEVISTE, @BragerTaxLaw.com, BragerTaxLaw.com. Thank you for watching my video and have a great day.